Do I have a case for legal malpractice? Good afternoon. My name is Neil Burns. I'm a lawyer. I represent victims of legal malpractice here in Massachusetts, along with my partner, Roshan Jain. We've been here at 6 Beacon Street for many, many years, represented hundreds of victims of legal malpractice, and I've been asked to talk a little bit about what are the elements of legal malpractice and do I have a case? When someone says, do I have a case? So there's 6 things we look for. The first is there attorney-client relationship? Sounds simple, but people think that there may be a relationship with an attorney, such as an estate attorney, when the attorney represented the estate and not you. That's a common misunderstanding. So we need to have a relationship. It doesn't have to be a signed fee agreement. Doesn't have to. You don't have to have paid the lawyer, but it helps to be able to prove that you had an attorney-client relationship. Then there's duty and breach of duty. So duty, did the attorney have a duty to do something? If you hired him or her to do something and they didn't do it or they fell below the standard, that would be a breach of the duty. And for example, if they blow the statute of limitations, it's 3 years from the date of an accident, they don't file suit, they come up with some excuse. We had one where the attorney sent an email letter to a client in another country 15 minutes before the 3-year statute was going to run. So of course he couldn't file suit in 15 minutes from another country here, and that was determined clearly by the insurance company to be malpractice, to fall below the duty that that attorney had. Then the next step is, did that breach cause damages? In other words, the attorney could do something wrong, for example, a car accident. There's no damage to your vehicle, you're not damaged. There's no damage to you, even though the attorney did something wrong. He sent the wrong letter, she filed the wrong claim. If there's no damage to you, there's no damage. And finally, there's sort of 2 elements, so 2 more aspects. One is they have to be provable damages, and 2, it has to be collectible. We have to be able to prove the damage. So if you have a broken leg, maybe you can't prove exactly how much the damage was, but you can certainly prove that you were damaged, you missed time from work, you're unable to run the way you used to, or ski the way you used to, or take walks with your partner or your kids the way you used to. And then collectability. If there's no insurance by the attorney, then how can we collect on it? So we have to look at that as the final aspect of, was there a malpractice case that you can file a claim on. If you have a question, if you've been wronged by your attorney, call Burns and Jain. It's a free initial consultation. My partner, Roshan Jain, or myself, Neil Burns, willing to help you. We're aggressive, we're effective, and we care about you. We want to help our clients. Call 617-227-7423. Thank you.